Dear friends, today we will discuss about a social evil which all of us face almost every day, everywhere. And above all, I am sure that we all hate it. We talk about it all the time, but we never take an initiative to prevent it. And the shame is that most of us consider this sin as a habit and part of our life. Yes, you guessed it right. We are talking about the biggest evil of our society, that is corruption, which is spreading like cancer in every single aspect of our life, and it's really growing massively. Earlier, bribes were paid for getting wrong things done, but now bribe is paid for getting right things done at the right time. Today, I, Anupama Pandit Saxena, will be discussing with you a very relevant topic, that is the Prevention of Corruption Act 1988, which is also a very important unit of Criminal Law Semester 2nd, paper FSHT 201. Let's take a look on the topics and areas that we are going to cover in our session. Module 1 will be covering Introduction and Concept of Prevention of Corruption Act. In Module 2, we will discuss the contents and structure of the Prevention of Corruption Act. In Module 3, we will discuss the objective of Prevention of Corruption Act. In Module 4, we will discuss amendments of the Prevention of Corruption Act. So let's start with Module 1. Introduction and Concept of Prevention of Corruption Act. This first module will not only introduce the Prevention of Corruption Act 1988, but it will give us a fair idea about history of corruption in India as well as the legislative efforts made to control this evil. This module will also tell us about the salient features of the Act along with some important concepts relating to it. Corruption is not a new phenomenon in India. It has been prevalent in society since ancient times. History reveals that it was present even in the Mauryan period. Great scholar Kautilya mentions the pressure of 40 types of corruption in his contemporary society. It was practiced even in Mughal and Sultanate period. When the East India Company took control of the country, corruption reached new heights. However, during his tenure as Governor General, Lord Cornwallis implemented some policies to decrease corruption. Regulation of corruption is in some form or other has a long history in India. In the pre-independence period, the Indian Penal Code 1860 was the main tool to combat corruption in public life. The code has a chapter on offences by public servants. Section 161 to 165 of IPC provided the legal framework to prosecute corrupt public servants. At that time, the need for a special law to deal with corruption was not felt. It was after Second World War. The situation changed drastically. The first law, mainly dealing with corruption and the attachment of property, was again a pre-independence wartime ordinance which we called Criminal Law Amendment Ordinance 1944. It was enacted under the Government of India Act 1935. After the Second World War, the existing provisions under the IPC and other laws had proved inadequate to deal with the cause of bribery and corruption of public servants, which had increased greatly during the war years. The lawmakers felt that drastic legislative measures need to be taken for combating corruption. Hence, the Prevention of Corruption Act 1947 was enacted. It was the first direct and consolidated law on the subject of corruption, which was enacted in independent India to supplement the provisions of IPC. After that, Criminal Law Amendment Act 1952 brought some important changes into law relating to corruption. Thus, there were several legislations already enacted to fight corruption in India before Prevention of Corruption Act 1988. Therefore, to consolidate all those existing laws, the Prevention of Corruption Act 1988 came into force on 9th of September 1988. This act incorporated the Prevention of Corruption Act 1947 the Criminal Law Amendment Act 1952 and Section 161 to 165A of the Indian Penal Code. It also enlarged the scope of the definition of the expression public servant and amended the Criminal Law Amendment Ordinance 1944. The Act of 1988 also widened the coverage, strengthened the provisions and made them more effective. Since then, this Act is the main anti-corruption legislation in India. This Act extends to the whole of India except the state of Jammu and Kashmir, and it applies also to all citizens of India and outside India. Now, let's take a look on the salient features of this Act. This will give us a brief idea about the provisions which we will discuss in detail in the next module. The first important feature of this Act is that the term public servant is defined in the Act, and this definition is broader than what existed in the Indian Penal Code. Another feature is that the concept public duty is introduced in the Act, which was really a new concept for this kind of legislation. Offences relating to corruption in the IPC have been brought in the Act, and they have been deleted from the Indian Penal Code. Another very important feature of the Act is that it provides all cases under the Act to be tried only by special judges, and the proceedings of the court have to be held on a day-to-day basis. Penalty prescribed for various offences are enhanced. This Act made the amendments in Criminal Procedure Code to provide for speedy trial. It has been stipulated that no court shall stay the proceedings under the Act on the grounds of any error or irregularity in the sanction granted unless in the opinion of the court it has led to failure of justice. Other existing provisions regarding presumptions, immunity of bribe giver, investigation by an officer of the rank of Deputy Superintendent, access to bank records, etc. have been retained. Thus, it is clear that the Prevention of Corruption Act not only defined the basic concept relating to corruption, it also ensures for proper investigation, special procedure and speedy trial. This is why this is the main legislation of prevention of corruption in India. The Prevention of Money Laundering Act 2002, Whistleblowers Protection Act 2011, the Lokpal and Lokayukt Act 2013, Black Money, Undisclosed Foreign Income and Assets and Imposition of Tax Act 2015 and some other legislations are also relevant for the problem of corruption. Besides, like the Director General of Income Tax Investigation, Central Vigilance Commission, that is CVC, and Central Bureau of Investigation, that is CBI, deals with anti-corruption initiatives, but in this presentation we will focus on the Prevention of Corruption Act 1988. Now let's move on to Module 2, that is Contents and Structure of the Prevention of Corruption Act. The Prevention of Corruption Act 1988 has total 31 sections divided into 5 chapters, in which the last section, that is 31, is repealed by the Repealing and Amendment Act 2001. As we have discussed in the first module, that this act ensures for proper investigation, special procedure and speedy trial in the case of corruption. The contents of the act provides for the same objectives. Chapter 1 of the act is the preliminary chapter, which contains only 2 sections. This chapter provides in section 1 for the short title and extent of the act. Section 2 is an important section. It provides for the definition of important terms in the context to the Prevention of Corruption Act 1988, which we will be discussing later in our session. Chapter 2 contains section 3 to 6, and it provides for the appointment of special judges, cases triable by special judges, procedure and power of special judge, and their power to try the cases summarily. Chapter 3 is from sections 7 to 15. This is an important chapter, as in this chapter various offences and penalties are given for the acts amounting to corruption. Chapter 4 contains only 2 sections, that is 17 and 18, and it provides for investigation into cases under the Act. Chapter 5 is the last chapter, which contains sections from 19 to 31. However, as we have already discussed, the section 31 is repealed. This chapter is related to sanction for prosecution and other miscellaneous provisions. Now let's move on to Module 3, that will tell us about the objective of the Prevention of Corruption Act. The preamble of Prevention of Corruption Act 1988 mentions its objectives, and it reads as an act to consolidate and amend the law relating to prevention of corruption and for matters connected therewith. This objective will be clearer by reading into the Statement of Object and Reasons published in the Gazette of India Extraordinary Part 2, Section 1, dated 12/9/1988. As per the Statement of Object and Reasons, the object of the Act is to amend the existing anti-corruption laws with a view to making them more effective by extending the scope and ambit of the definition of public servant, and to bring to within its sweep each and every person who held an office by virtue of which he was required to perform any public duty. Other object is to make the existing anti-corruption laws more effective while widening their coverage and by strengthening their provisions. Let's move on to Module 4, and we will discuss in this module about the amendments of the Prevention of Corruption Act. In May 2011, the Indian government ratified 2 United Nations conventions. The United Nations Conventions Against Corruption, that is UNCAC, and the United Nations Convention Against Transnational Organized Crime, that is UNTOC, and its 3 protocols. The convention imposes a number of obligations on the member states to ensure measures in the domestic law for criminalization of offences relating to bribery and put in place an effective mechanism for its enforcement. To fulfill this international obligation, when the Indian Parliament has passed the Lokpal and Lokayukt Act 2013, it amended some of the existing laws relating to corruption. Thus, the Prevention of Corruption Act 1988 was also amended along with the Commission of Inquiry Act 1952, the Delhi Special Police Establishment Act 1946, Code of Criminal Procedure 1973, and Central Vigilance Commission Act 2003. The amendments made in the Prevention of Corruption Act 1988 are as follows. In Sections 7, 8, 9 and 12 of the Act of 1988, the minimum sentence prescribed earlier was 6 months. After the amendment has been enhanced to 3 years. In this section, the maximum period of punishment was 5 years, which has been enhanced to 7 years after the amendment. Section 13 of the Act deals with criminal misconduct by a public servant. The minimum imprisonment prescribed earlier was 1 year, which has been enhanced to 4 years by the amendment. The period of maximum sentence is also amended and fixed to 10 years, which was earlier maximum 7 years. The another section which is amended is Section 14. Section 14 of this Act relates to habitual committing of offences under Section 8, 9 and 12. Earlier, the minimum punishment prescribed therein was 2 years. Now, this minimum punishment is fixed to 5 years. In this section, maximum punishment 7 years is now enhanced to 10 years. In Section 15, no minimum punishment was prescribed before the amendment. In the amendment position, the minimum punishment is 2 years. The maximum punishment is now enhanced to 5 years, which was 3 years in the original statute. Lastly, Section 19 of the Prevention of Corruption Act 1988 has been amended on the point of sanction for prosecution. In this section, after the words "except with the previous sanction," the words "save as otherwise provided in the Lokpal and Lokayukt Act 2014" has been inserted. So, we can say that the amendments basically enhance the punishments of the previous offences provided under the Prevention of Corruption Act 1988. Now, let us take a look at the proposed amendments to the Prevention of Corruption Act 1988, which are still pending in the shape of Prevention of Corruption Amendment Bill 2013. The highlights of the bill are as follows. The Prevention of Corruption Amendment Bill 2013 amends the Prevention of Corruption Act 1988. The Act covers the offence of giving a bribe to a public servant under abatement. The bill makes specific provisions related to giving a bribe to a public servant and giving a bribe by a commercial organization. The bill redefines criminal misconduct to only cover misappropriation of property and possession of disproportionate assets. The bill modifies the definition and penalties for offences related to taking a bribe, being a habitual offender, and abating an offence. Powers and procedures for the attachment and forfeiture of property of public servant accused of corruption have been introduced in the bill. The Act requires prior sanction to prosecute serving public official. The bill extends this protection to former officials also. The bill makes giving a bribe a specific offence. The bill has deleted the provisions that protect a bribe giver from prosecution for any statement made by him during the corruption trial. The bill has replaced the definition of criminal misconduct. It now requires that the intention to acquire asset disproportionate to income also be proved, in addition to possession of such assets. Under the Act, the guilt of a person is presumed for the offence of taking a bribe, being a habitual offender, or abating an offence. The bill amends this provision to only cover the offence of taking a bribe. The proposed amendments are not free from criticism, but they will definitely strengthen the Prevention of Corruption Act 1988.